The Karen Reed case follow-up just continues. In our previous episode, we looked at the lawsuit that Karen filed against 8 different parties. In this episode, we're going to tune into a status conference in the lawsuit against her.
You lost. And you know what you did.
This is About the Law. I'm attorney Andrew Myers. With me is California attorney Yolie Medina. Hey, Yoli, how are you?
I'm fine. How are you?
Oh, I'm hanging in there. I'm hanging in here. I'm not really sure where to start today. You know, the other day we did our episode where we read through Karen Reed's new lawsuit that she brought against 8 different parties. And she's saying she'll bring in 2 more. And that's in the Bristol County, Massachusetts Superior Court. Of course, there is the lawsuit that was brought in Plymouth Superior Court against her. And as we start this episode, we are just waiting. We're recording this, folks, for a status conference to start up. And that has not started yet. But what are your thoughts as we start out on this episode, Yoli?
Well, is it true that Judge Kearney is listed as the judge for the status conference?
Well, she's listed. I mean, I don't know. I really don't know. I'm monitoring. That was the screen we're getting out of the court right now. She is listed as the judge. It's kind of hard to believe that she would be on this case. You know, she tried the criminal cases, both of them, in 2024 and then again in 2025 in the Norfolk County Superior Court in Dedham, Massachusetts. And then, as a lot of judges do, they ride circuit in Massachusetts. A lot of them, not all of them, but many of them ride circuit. I've seen judges in Boston and Suffolk, and then the next time I appear in Middlesex up in Woburn, there they are. So they travel around. So yeah, they rotate. So yeah. So she was sent down to Plymouth, and now the case against Karen Reed is in Plymouth. And so her name was on the roster. We're not real sure if that's how things are going to go. At least I'm not real sure right now. We will see. But that status conference is scheduled to start in 5 minutes. And so we're watching. As soon as it starts, we will take a look at it. One thing that a lot of us who are watching the trial or watching all the Karen Reed events saw this week. And what we saw this week is, remember the controversy about all the sidebars?
Yes,
well, finally, after everyone in the world, us included, ran episodes on where are the sidebars. Now, the court, Judge Kearney, has issued an order in response to the Commonwealth's motion seeking clarification regarding sidebar transcript impoundment. The court issues the following. So that's interesting. Karen Reed's attorneys way back on July 31st, months ago, filed a motion to make the transcripts of the sidebars public.
And nothing happened.
Yeah, that came and went, totally ignored. Now, just very recently, within the last 10 days, Adam Lally, stepping back into the case, filed this motion seeking clarification that she is talking about here. And now there's an order that just came out November 19th.
You know, does the Commonwealth have like deadlines when they're supposed to respond to a motion?
For the parties, yes. There are strict deadlines. But for the court, no. I found that early in my practice. You'd do a motion hearing, or God forbid, a trial. You would try a case to the bench, and there was no deadline. Sometimes you'd get something right away, and sometimes you'd go 30 days. But no, is the answer to your question. No, there's no real deadline. So it is hereby ordered that all sidebar conferences prior to both trials and occurring during the trials, other than those that discuss jurors or juror issues, shall be transcribed and made available. The court finds that good cause exists to extend the impoundment orders for all sidebar conferences that discuss jurors or juror issues. Well, yeah, I can understand that. Jurors serve and they are allowed the protection of privacy. No juror, wants their name publicized. They have the right to go out to the media, as we've seen after both Karen Reed trials, but they don't have to.
Right.
So, see Uniform Rules of Impoundment Procedure Rule 3A. And I remember that Corey Hopkins from Carolina had filed to get these, and she was roundly ignored. And the attorneys for Karen Reed were roundly ignored when they tried to get the sidebars. But Adam Lally files, and here's an order. So apparently they had not been transcribed yet, and they have to be transcribed. And so.
Well, I think, the court reporters take down everything. It's a matter of they take it down in their language, I guess, their little shorthand stuff.
Yeah.
And then they transcribe them. So maybe they haven't been transcribed, but they're there with the court reporter, the data.
But what do you read into that Karen Reed's attorneys had filed a motion way back in July to have this done, and it was never done, and it's only done now? I find that kind of interesting.
Well, I do find it interesting. It almost seems like there is a bias. She's going to ignore what the defendant brings forth, and she's going to act on what the prosecution brings forth. Yeah. That's what it looks like. Just I don't know why she would have ignored that motion. And that's why I was asking if there is a certain deadline when a court has to respond. So she gets away with it because there's no deadline for her to respond to a motion. But, her actions look like she's responding to the state or the Commonwealth, but not to the defendant's motion. It's just weird. I don't know.
And all along, I've said this, I've pointed out that I am an attorney licensed to practice in Massachusetts. I do have cases pending in the Superior Court and the district courts. So I have to be really careful what I say. But you know what? It doesn't hurt me at all to say that this is not a good look.
No, it's not.
It's not a good look at all.
I'm not saying anything bad. I'm just saying that the way it looks, it looks like, it's not a good look.
That a judge is biased is not bad. I'd say it's just horrendous. People all over the world are saying there's something wrong here. And I will say that. It is bad. I disagree with you.
But I'm not saying anything bad about anybody. I'm just saying what the facts look like, because those are the facts.
Those are the facts. And, the other thing that happened this week is that person has now jumped in to run against Norfolk County District Attorney Michael Morrissey. It is federal prosecutor Adam Deach. He declares a run for Norfolk County District Attorney. And interestingly, this is an article from WCVB Channel 5 in Boston. He is a former assistant U.S. attorney who had a leading role in the federal investigation into the handling of the Karen Reed case, and he announced just Tuesday of the week we're recording this episode that he is running for Norfolk County District Attorney, which I thought was interesting. Adam Deach of Quincy it's Quincy, folks, not Quincy, left his position as an assistant U.S. attorney for Massachusetts on November 7th, just a couple of weeks ago, to launch his challenge to current district attorney Michael Morrissey.
And so was he on the Karen Reed case?
He absolutely was. Yes. Let's read his quote. I left my job as a federal prosecutor because it's clear there's a problem in Norfolk County. Victims are not getting the justice they deserve. The public has lost faith in the system, and someone has to do something about it, he said in a written announcement about his campaign.
Well, that says something.
In his announcement, he touted his success as a federal prosecutor, handling corruption cases across the state, including a Massachusetts State Police CDL bribery scandal, drug license fraud and bribes, and a fraud case involving Boston community activist Monica Cannon Grant. Deutsch also served as the lead assistant U.S. attorney in the federal investigation into the death of Boston police officer John O'Keefe and the state investigation and prosecution of Reed. Michael Morrissey, interestingly, a lot of people have said, gee, where is he? We haven't heard anything from him recently. Morrissey has been largely absent from the public eye since June, when Reed was found not guilty of the 2 more serious charges, 3 actually, brought against her in her retrial in the death of O'Keefe. Morrissey has been the district attorney since 2010. So there is talk that Michael Morrissey will not run. He's been in there since 2010. So enough is enough, maybe?
Probably.
Probably enough. So I thought that was interesting, that now there are 3 known candidates. We had invited one of them, and then things got kind of crazy here, and we had to cancel that. If our viewers would like to see interviews with all of the candidates, especially this one, I would just love to hear what he has to say. I would love to hear what he has to say.
Absolutely. I mean, it does say, it says a lot that he's wanting to run, and he was one of the federal prosecutors involved in the Karen Reed case. So, it doesn't take a genius to see that there's something going on.
It's interesting. And at the same time, the FBI, I've seen it down in the comments, both in this case and the Koberger case and some other cases that we followed. People express the feeling and the thought that, let's get the FBI in, they'll straighten everything out. And I don't know where that idea comes, that there's some kind of a great, wonderful authority. I mean, in the Whitey Bulger case, they were dirty as possible. A former Boston FBI office, manager, the head of the Boston FBI office, ended up doing time for murder down in Florida. The fish rots from the head down, going all the way down to the Kennedy assassination. Anybody who asked a question was called a conspiracy theorist by J. Edgar Hoover. And J. Edgar Hoover liked to get dirt on people and then blackmail them. And that's a well-known fact. So for people that think that the FBI is some kind of a great, wonderful, knight on a white horse in shining armor, now I know this guy was a federal prosecutor. It's a different office, but at the same time, I don't know. So I am still monitoring. We started a little bit before the status conference in the Karen Reed case was to start. Oh, Yoli, look, it seems like we are now suddenly getting access to the hearing.
Oh, good.
Your Honor, let me just quickly respond to that. First of all, I'm a little concerned by listening to my brother counsel read from what looks like a scripted message that doesn't seem to deal with any issues, because there's been no motion to compel that's been served on us relating to those answers. There's been nothing filed with the court. Instead, my brother counsel is reading from a script for what I'm guessing is some other purpose. And what we'd like to do is we'd like to just...
Attorney Waters, excuse me for interrupting, but maybe we'll take this as a 9C conference. You heard what he's looking for. What do you say to it?
Your Honor, actually, I don't know what he's talking about, to be candid. I think that Karen's statements have been consistent, and they're certainly consistent with the lawsuit that's been filed in Bristol County. So my brother counsel is going to have to be more specific about what he thinks is inconsistent. I don't think it is at all. And that's usually why motion practice is a good idea.
Attorney Diller, I guess we'll consider the 9C conference conducted and file whatever motion you want to file.
Thank you, Your Honor.
Anyone from, what's the status of the discovery with CNC Hospitality and GNS? Attorney Diller, did you receive responses?
I did. Well, both parties had reached out to us over the history of this case. We may have propounded that discovery even before, while the criminal matter was going on. maybe around the time of the stay. But they then reached out to us at separate occasions and were very upfront about the fact that they're compiling discovery and needed more time. We allowed that additional time. Yesterday, we received some discovery, which I think I indicated to you I have not reviewed yet, but we have received discovery from both bars. One bar, and forgive me for not recognizing which one is which, one bar may have sent me some preliminary discovery a couple weeks ago and then supplemented it yesterday. The other bar sent me a batch of discovery yesterday, none of which have I had an opportunity at this stage to review.
Okay. Anyone else want to offer anything on behalf of any of the parties? Attorney Hassett on here for Waterfall.
Yes, Your Honor. Attorney Hassett for Waterfall.
Afternoon. Do you want to offer anything?
Your Honor, I would just say that with respect to the discovery, we have in fact responded to the plaintiff's discovery after an extension was granted. We did the interrogatory answers. Those have been complete. The document responses were, as Attorney Diller indicated, in 2 stages. We completed that as well. We have yet to propound discovery ourselves at this point. Obviously, there's a history in this case that occurred on through 2 criminal trials. It was our approach to see what documents were produced from the various keeper depositions and the other document requests among the parties. And then from there, after looking through the documents, make a decision as to what more pointed interrogatory answers we would propound. And as was indicated earlier, we've got a fairly lengthy discovery on a average tracking order, which permits discovery through next August. So in terms of our own discovery and our plan on propounding it, we were hopeful that we'd be able to wade through some of the voluminous documents first.
Who's here for McCarthy's? Is it Attorney Smith? Rick Donovan, is Attorney Smith?
She is, yeah. Attorney Smith.
Yes, Your Honor, I asked her to unmute.
Yes, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Attorney Tamara Smith for CF McCarthy's. Thank you for the opportunity to speak. Yes, as has been stated, we did produce several hundred pages of documents yesterday, have responded fully to the plaintiff's answers, to the plaintiff's interrogatory requests. And like counsel for Waterfall, there's, as indicated in this call today, over 1 million or about 1 million pages and documents that are forthcoming. So the thought here would be to see what is there so that there's not duplication of effort and additional requests put out that are already answered by what is already forthcoming.
So we joined this in progress. We were not privy to what was going on, if there was anything going on in the status conference for the first 40 minutes. And right in the middle of it, somehow there was a technical glitch. They brought us in the middle of this, 9, 10, 11, 12 person Zooms. People keep popping in and out. What they're discussing now, which is kind of common in a status conference in Massachusetts, is where is discovery? Are you folks cooperating and answering interrogatories, which are written questions that are asked under oath and have to be answered under oath, and requests for production of documents? And just to comment that 1 million documents could be nothing. I've been involved in litigation where they send you, the kitchen sink. So the fact that there's a volume of documents does not mean that there's a substantive amount of information that's relevant.
Well, it's great you're trying to agree to something, but again, I think it's difficult to have an agreement without knowing who's going to be involved in the other case, who the attorneys are. Attorney Waters, what's the status of the notice to the governmental entities?
Yeah, you talking about the presentment letters, Your Honor?
Yes.
I think if they weren't sent yesterday, they'll be being sent today. And we've had conversations with both counsel for those entities about having a shortened presentment period. we expect agreement on that. I got my fingers crossed, but we expect agreement on that, in which case we won't be delayed in processing whatever procedural or motions that those parties want to make in that Bristol County case.
What's the status on the service on the individual defendants in the Bristol case?
The answer is I don't know, Your Honor. I haven't received information where we've gotten good service, and if we've not gotten it, I expect to get it shortly. My colleague Aaron Rosenberg can specify to that.
Your Honor, we've got counsel for, I believe, 2 of the individual defendants in the Bristol County case. One counsel has already agreed to accept service. The other counsel suggested that he will. We're just going back and forth. So we're hopeful we'll be able to get acceptance from the majority of those defendants and only have to serve a couple. So we don't foresee any delays on that front.
Attorney Diller, you talked about consolidation. Attorney Waters said they weren't going to move at this time. You, Attorney Diller, intend on moving to consolidate at this point?
We had discussed so the answer is yes, for purposes of discovery only, just to the extent that that works itself out. There was discussion during that entire motion practice that took place over the last 2 months. The counsel for these other parties had all reached out. So we have spoken with all of the counsel who were involved in the Bristol case because they were apparently going to be brought into this case. So there was that discussion with them. So I do know who that counsel is. I have the briefing from those counsel. There was discussion within some of the briefing that it should be consolidated for purposes of discovery purposes. I don't know where things stand because it's now outside in the Bristol case, but I do expect that there's awareness of who all the lawyers are, and we could potentially discuss options. Obviously we had wanted this to all resolve itself months ago, and unfortunately it wasn't until Monday night that the defendants withdrew their motion and started on a different track with a different mindset. But we will happily be proactive in trying to get that moving in the best direction for our case in the wrongful death case.
How much time do you think that would take?
Well, what I don't know, Your Honor, is whether some of the parties are going to move to dismiss in the Bristol case and whether that will hold up the discovery there. That's the big unknown. So I wish I had that crystal ball, and I don't today, but I anticipate that there are some overlapping parties that may stay in the Bristol case, to which we'll need discovery there, and that discovery will overlap. I want to be clear that we're agreeing for discovery purposes to avoid prejudice. We are tabling whether or not these matters need to be tried together. That will only be known once we have full understanding of what comes out in discovery.
Let's pick a date in December so we can find out where the Bristol action is at and find out what other discovery issues remain so we can try and sort through those. Do you anticipate filing a motion to compel, Attorney Diller?
Yeah, the interrogatory answer, yes.
Okay, so let's pick a date for that. A date in December. When can you have the motion, sir?
We can start working on that right away. Within probably the Tuesday after Thanksgiving is what I believe we could shoot for.
December 2nd gives the defendant till December 12th. Let's pick a date the next week. We'll have a hearing on the motion to compel and a further status hearing. How about December 18th? Is that an issue for anyone?
Your Honor, it is for me. I have pre-existing hearing scheduled that day, but the 16th and the 17th, I'm open.
If I could have just a moment, Your Honor, to confer with my client. The 16th and 17th don't work for Ms. Reed. Either the 18th, I know that that's bad for Mr. Waters. The 19th would work.
19th work.
Attorney Jackson, I can understand Ms. Reed wants to be there at every matter, but I don't necessarily think there are constitutional issues relative to the civil case.
I agree. I'm not suggesting that she has a constitutional right to be there, but I know that she wishes to participate in her own defense, and she would like to be there if we can accommodate her schedule.
Right, but if the court starts having to accommodate every party's schedule, it would grind the courts to a halt.
I understand. I get that. There's only one defendant, though. So, for what that's worth.
There are other defendants in this case.
Your Honor, for what it's worth, I can also do December 19th.
Will it be remote, Your Honor, by Zoom? I have things that week, but if it's going to be remote by Zoom, then I can try to, I can definitely be available and then not worry about moving things around on the week of the 15th.
Hang on 1 second. I have to have the clerk check something. No, I'm checking the schedule here, Clerk Donovan. How about 2 o'clock on December 19th? We'll schedule it virtually for now.
Thank you.
That works, Your Honor. Thank you.
Thank you, Your Honor. I appreciate it.
All right, we'll see everyone then. Thank you.
Thank you,
Thank you, Your Honor.
Okay, so just for the record, this matter is continued to December 19th, 2025 at 2 p.m. for the motion to compel and further status, and this hearing will be held by Zoom at this point in time. Thank you all.
Thank you.
Did you follow all of that, Yoli?
Yeah, I did.
Okay. What a nightmare with the boxes kept opening and closing. It was up to 12, then it was down to 9, then it was up to 11.
Hollywood Squares. It was like Hollywood.
I think what happened was that somebody was just asleep on the switch. Someone was just asleep on the switch because at some point, they just started the hearing. They just flicked the switch on and they were in the middle of the hearing. And at that point, it was hard to follow, but they were discussing all the issues, that come with, scheduling. There was apparently an issue with not everybody has done their discovery. Now, bear in mind that this case, which was brought by Paul O'Keefe, the executor of the estate of his brother John O'Keefe, was brought during the trial. Remember that? It was brought during the second trial of Karen Reed. And Karen...
Yeah.
Yeah, it was partially stayed. The discovery was not stayed. It was only stayed with respect to Karen and not her father, and that was an issue. Then they had to scramble around and get an attorney for William Reed, and it was stayed with respect to Karen. And so now, what I picked up from this early on in the snippets that we got was that what I had been told initially about 3 weeks ago was true. They did originally intend to bring the new case of Karen Reed versus the 8 defendants. They tried initially to bring that by a motion in a Massachusetts Superior Court Rule 9A motion package. You don't just file motions in Massachusetts. We are required in a civil case to follow a procedure at Superior Court Rule 9A. We have to send our motion to the opposing parties. Then they send us their reply, and then we are required to put it together into a package and file what's called a Rule 9A package. And I had been told that was what was being done a few weeks ago. Then I thought I had been sandbagged because they then brought this new case in Bristol County. No, apparently what I picked up from the hearing we just saw now, no, that was their intent, and they did do that, and I wasn't sandbagged. It's just that there was a change in procedure just on Monday, the 17th of November, whereupon they decided, forget the Rule 9A package, forget about bringing this case into the existing Plymouth County case that we just saw the Zoom in, file it on Monday as its own separate lawsuit. So that's what I picked up from all of that.
That's what I picked up as well. I picked that up. I also picked up that, it's obvious that Alan Jackson practices criminal law because you would never say on a hearing something like this, I got to check my client's schedule. Normally,
I've done that.
normally those things aren't considered, but being that this is a high profile case, she wants to be there. But
I don't blame her.
The judge said that there's not a constitutional issue with her not being here.
Yeah, but I've had clients that want to actively participate in their cases, and I give them all due regard because, after all, I'm working for them. It's their claim. It's their case.
Right.
They want to be involved. And so I would have asked that if I had that type of a client. I've had clients that don't want anything to do with their case until it's over. We either settle it or try it. But I did understand what he said. And of course, Alan Jackson understands that it doesn't rise to a constitutional level in a civil case. But at the same time, he wants to protect his client, a high-profile client, a client who did take an active role in her criminal cases. Remember, in the second trial, she insisted. She went up to the sidebars. They had filed a motion before the second trial where she went up to sidebar, which doesn't always happen. So,
right.
There are discovery issues.
It is a high-profile case, and she's a high-profile person. And it was interesting that he said there's only one defendant.
Well, but I think what he meant, I understand what he meant. He meant that it was one personal defendant. Do you know what I think it was? I think it was just parochialism. Alan Jackson and Eliza Little have run into this before, and I've noticed it. And I haven't lived in New England my entire life. I've only been here for 50 years, but people in New England are a little bit parochial and don't like outsiders. And I sensed a little bit of that, didn't you, in the Norfolk County Superior Court trial in Dedham? That's not how we do it in Massachusetts. So I sensed a little bit of that on the court's part. I really did.
I feel like that's what it is too. California and over there, Massachusetts.
And so there's an issue as to consolidation that was discussed, but that is still something that's up in the air. Apparently, before we were allowed into the clip, there had been an agreement with respect to discovery, not with respect to the trial. That's still an open question. But apparently, there's been some kind of an agreement amongst the attorneys that we're not going to do multiple discovery just because it's similar parties in two different cases. Why would you have to do 12 different sets of interrogatories all over again in a second case? So apparently there's been some kind of an agreement with respect to the discovery, but no decision has been made yet with respect to the actual trial. Now, if one of these attorneys wants to call me, I'm a Massachusetts attorney. I talk to Boston attorneys all the time, and I've talked to some of the attorneys that are involved in this case, both directly and tangentially, protecting all of my sources. But if someone wants to call me and let me know off screen what's up with that or not, I'll be happy to know. Now, do you think that they will have a magistrate if the discovery is going to be, together, both cases, if both cases are going to be doing discovery as one case, do you think they'll have to have a magistrate to I think it would be a very good idea, but I don't see it often. I think it's a really good idea. And I did an episode on this a long time ago when they were fighting in the Koberger case. I don't know if you remember that. I had done an episode, and I actually talked to a person that did that type of refereeing and discovery. I don't see it often. I think you're right. I think it's a great idea. But now what I picked up was that another status conference will be held on December 19th, but that's only with regard to a discovery issue. Apparently, someone gave an answer to interrogatories. And folks, this is what civil cases are all about. This is what we spend all of our time doing, is discovery, interrogatories, requests for production, all that good stuff. I just got some off my desk yesterday, and I have a deadline before Thanksgiving of getting some more discovery out. In any event, someone didn't answer their interrogatories to the liking of whoever sent them out. So that's what the issue is in the status conference on December 19th at 2 p.m. And that will be held virtually. So that doesn't sound like it's going to be a cataclysmic event in the continuance of the Karen Reed saga. I think it's just going to be, one of those things that is very important to us civil attorneys. But, I think it's going to be a big meh. Unless something could happen between now and then, we don't know. But the big question is, are the two cases going to be meshed and consolidated? That's a big question.
Yeah.
What did I miss?
Nothing much. I mean, it's just a big problem with trying to coordinate these types of cases into, how they're going to do it, and the redundancy of the cases and what's overlapping and what isn't, and the many parties that are involved. So I don't know.
I don't know either. What?
In this type of case, we have in California complex litigation, at least in Orange County.
Yeah.
Where all the complex cases go that have multiple parties and all this stuff.
Well, that would be a good idea. We have a business litigation section, but this isn't a business case. And they take care of complex business cases because, obviously those get extremely wound up. But so there will be a continuation December 19th. That's a week and a day before Christmas. I don't expect that to be a big deal.
Well, it depends on what they're trying to compel, right? I mean,
true.
What information are they trying to compel? Because we don't know. And when they file the motion, we'll probably get to see what it is they are wanting to compel them to respond to.
And I would highly recommend that the attorneys in this case, I don't care if there's 12 of them and one of me. I don't care. I would highly recommend that they resolve it somehow between now and December 19th, because courts do not like discovery disputes. They just don't like them. I know early in my career, I did get involved in some nasty discovery disputes, and every single one of them, the Massachusetts courts sent us out in the hallway and said, resolve this. I really don't want to hear it. And if I do, I don't think either one of you is going to be happy with the result. Or one of you is going to be really unhappy, and the other one will be, so resolve it. So my recommendation, I don't care if there's 12 attorneys there and I'm one attorney. My recommendation is just, I know it's painful. I know coming to an agreement on discovery can be painful, but what's more painful is appearing in front of a judge who doesn't want to hear any of it.
Right.
Is that how it is in California, that the courts really don't want to get there?
I can't even get, okay, so like I told you, if I file a motion, you have to meet and confer, and if you don't resolve it, then you file a motion, and the motion, you get a date, and usually it is after the trial date, because that's
that makes no sense, does it?
No, it makes no sense. So then what you have to do is you have to file an ex parte to shorten time and get the motion heard before the trial date. And it's so cumbersome that it is in LA. They actually have in LA County, they actually have like mini discovery conferences with the judge, where if you meet and confer, you can't get it together, you can't resolve it. You schedule a mini conference to try to resolve it before you file a motion to compel. I mean, it's so hard to practice civil here. It's like double the work. I mean, it's really frustrating. So.
Well, you mentioned you have to meet and confer. We have the same thing in the Massachusetts Superior Court. We have the Superior Court Rule 12E. And right when they started the clip, again, they started in the middle. We were sitting here talking, and we didn't have privy, and neither did anyone else, to the actual full hearing. But they were saying, how, well, that's your 12E conference. That's what that's all about. Before they even start the process that I described earlier about sending your motion to the other side, getting their reply, you can't even start that until you do a 9E discovery conference. I would have, if we're on the opposite sides of the case, before I even filed a motion to you, I would have to call you. Now, some attorneys kind of sleaze around that, and they'll just send an email stating their position, and then the last sentence is, please consider this our conference. Sometimes you can get away with it, but if push comes to the courts really don't like that. They want us to talk. We may disagree. I may be suing your client, or you may be suing my client, but the courts want us to be cordial and to agree and run stuff in front of each other, because you talked earlier about how the California courts are clogged up. Ours are too. It sounds like yours are more clogged than ours are, but they're very busy. They've got a ton of cases. You go in there, they've got a pile of cases to dispose of that day. And as you see, every time you go in, it gets continued to the next day. So they really don't want to deal with these issues. But so I don't think, I might be wrong, I don't think there's going to be the fireworks in the civil cases as there were in the criminal cases. Elizabeth Little coming in and holding up the great big picture of the dog bites on John O'Keefe's arm. The fireworks over the experts. I think it's going to be more of this, perfunctory daily kind of stuff that civil attorneys deal with on a daily basis, things that you and I deal with every day. I don't know if there will be the attention. I really don't. There may be. Let us know down if you're still with us. If you're still with us, do you think that there will be the continued, heavy public interest in this case or not? And that's question A. Question B would be, are you still as interested in the Karen Reed case as you were during the criminal cases? So I guess.
I have a question. Do you think that, I think that the McCabe's and the Alberts, I would think that they would file, if they're going to file a suit against Karen Reed, they would file a counterclaim against her in the recently filed case by Karen Reed.
Well, you would think so. On the other hand, look how the Karen Reed attorneys kind of circumvented the feelings of negativity by the judge over in Plymouth County. When they floated the trial balloon that they wanted to raise all of these issues, the 1983, the civil rights and everything else, against Michael Proctor, against Tully, against all the others, and the town of Canton and the Mass State Police. The judge in that case was not very warm to that. He was not very receptive to all of those cases coming in, and didn't say it out loud, but indicated that he might not allow all of the claims and wouldn't allow all of the parties. And so rather than just file that as a counterclaim or a motion for third-party claims and all the other procedural hurdles they would have had to go through, they filed a whole different case. They filed a whole different case in another county. So that may be what the O'Keefe's attorneys are up to. I do not know. They have their own local attorneys. Karen Reed, as I pointed out before, has 7 or 8 different attorneys, and it's quite a group of attorneys. They have a lot of litigation power. Alan Jackson's firm and Elizabeth Little's firm, have a lot of power. They're out there in your neck of the woods in Los Angeles. So with all those attorneys collaborating and working together, they have the resources that are available to do that. And I wonder if the O'Keefe's attorneys have the resources to pull something like that, because it was, I don't want to use the word sandbagging, but it was a surprise. We were expecting Karen Reed's attorneys to bring a counterclaim or motion for third-party claim or other procedural things within the other lawsuit. But then they didn't. They didn't. So I don't know. Who knows what they will do? They had indicated the day before Karen Reed's lawsuit was made public, the O'Keefe's and the McCabe's had made it very clear that they were going to file this defamation suit against Karen Reed and against Aiden Kearney. But then things happen. So we don't know. It's in the background. It could be filed at any time. There are a lot of people following the case, and nobody has anything. As we record this episode, nobody has anything on that. The other new thing since the last episode that we did is there's a great book that's come out. Can you read that?
Howie Carr, Mass Corruption.
Yeah, this book has just come out recently. Howie Carr, for those of you who don't know, although he's syndicated nationwide, he's a local Boston talk show guy. He has been on the air for 30 years. I first remember I was working at a Boston law firm, and one of the other younger guys was just laughing his rear end off. I went to the other side of the office and said, "What the heck is going on?" He said, "Listen to this guy. Listen to this guy. His name is Carr, and he's excoriating the legislature." And he was reaming them, just literally, and just yelling and screaming about how crazy the legislature was, because they had just granted another in a series of huge legislative pay raise to the Massachusetts legislature in Boston. And it started there. It's gone down. I mean, the cognoscenti in Boston, the powerful people in Boston, hate Howie because he calls them all hacks. And I think I agree with him 90% of the time. And the other 10% of the time, he's very entertaining. So he wrote this book. It's called Mass Corruption, Volume 1, having to do with law enforcement or the cops.
Volume 1, huh? So
yeah,
there
Volume
might be
1.
more volumes.
He's written a bunch of books. He's written a couple of books about Whitey Bulger. He's written some other books about the Kennedys. He's written some other books. Howie says, "As a taxpayer of Norfolk County, I am hereby demanding a refund of my property taxes from District Attorney Michael Meatball Morrissey. Even if my neighbors and I were in favor of framing an innocent woman for a murder she didn't commit, which we are not, I would argue that we are being overcharged, massively overcharged. In the Karen Reed trial in Dedham, an expert witness testified that his lackluster company has been paid about $400,000 for their analysis of the murder of John O'Keefe." That was his, not mine. "Also, Norfolk County will be charged for the Lexus SUV these experts bought to do a Blippy-like reconstruction of the accident." Hey, we never heard anything about that. Remember, during the trial, it had been stated on the stand that they would sell the Lexus and the Commonwealth would get its money back. Remember that?
Yeah.
I've never heard anything about that.
About it.
So let's see. That will probably set us back another $80,000. The new car was used in the clownish stunt that involved the expert splashing himself with enough blue paint to make himself look like a Smurf. But there's more money being squandered. Don't forget the quote-unquote special prosecutor, mob mouthpiece, Hank Brennan, who is billing $566,000 for his very special services. If you're just joining us, I'm reading from Howie Carr's book, Mass Corruption. I'll just read one more paragraph. "And then there are the other two special counsels involved in a different related railroading, that of Aiden Turtleboy Kearney, who has broken most of the stories about this law enforcement scandal. One of them is a retired judge who is already collecting 2 pensions from us to the tune of $203,000 a year. Not a bad gig, I might say myself."
All right.
So I put in a request to interview Howie, and the mailroom manager called me on the phone 2 days ago. Those of you who listen to his show know who the mailroom manager is. She's in charge. She runs the thing. She pretty much, is in charge. She said, "Yes, we will have the opportunity to interview Howie on this very channel." So I hope that does happen. I hope that we are able to interview Howie. I'll give him as much or as little time as he wants. Usually our interviews, are in the 15, 20-minute range, but I would certainly welcome him. He's been in Boston for a long time. So
Yeah, that would be interesting. On Brian Walsh, though, they seated a jury, right?
yes, they have. That's the news hot off the press. As of the day before we're recording this, it had been reported that there were 12 jurors picked, 6 men, 6 women. But now at this point, the entire jury of 16 people has been selected. So that means I guess they'll take a week off. But then the actual opening arguments are going to start on December 1st. So they have Thanksgiving week off. So I don't know.
No,
If I was
next week is Thanksgiving.
Yes, it is Thanksgiving. So I just wonder, if I were picked for a jury, I would want to go right away. I don't want to waste any time. I've said that before with all those sidebars that we're now waiting for the transcripts. I would not be happy. I guess I'm a typical American. I want it now and I want it fast and I want everything.
It's going to take a while. Watch. It's probably going to take a while for the court reporter to transcribe all those sidebars.
Yeah, but if they'd have started it back in July, we have them now, or June. The Karen Reed 2 was done June 18th. I mean, okay, give them some summer vacation. That's fine. I have no problem with that, but it would have been done. Now, I have a question. I wonder if we will get both the transcripts of the sidebars that were kept by the official court reporter for the Norfolk County Superior Court, but also the transcriptions from the Norfolk County DA, because remember in a previous episode, we read that motion for clarification by Adam Lally, and he seemed to indicate that they have all of the sidebars from the second trial, but they only have 8 of them from the first trial. But that was their own transcription. That was their own court reporter. Remember, they brought a motion early on to have their own court reporter make their own transcripts. I'd like to see them both, the one that was kept by the Superior Court itself and the one that was kept by the Norfolk District Attorney.
Interesting.
I would like to see them both, just because there are so many questions about this case. There's just so many questions about this case. I would love to see them. I really would.
Yeah.
I'm not saying anything nefarious was going on, but
that's weird. So they wanted their own court reporter. I know in California we have to get our own court reporters. The court doesn't provide you court reporters. So over in Massachusetts, the court provides a court reporter unless you want your own.
In a big case like that, yes.
And why would they want their own court reporter? Why would the
You'd have to pick up your phone and ask Adam Lally. I mean, sometimes it's a matter of, and you've tried medical malpractice cases, sometimes you want your own transcript and you want it rushed because, your expert is on the stand. And then their expert is on the stand. And before you do their expert, you want your transcription right away. So it's possible that they wanted their own transcription so that they could get quick service. I know what I want to do. We had some great comments this week. Why don't we do our great comments that we had this week? And do you want to do the odds or the evens?
I'll do the odds.
Okay.
This is from 4 Spikers. Karen Reed, all the power to you for the entirety of what you have suffered, endured, and survived. Wishing you 100% success in the upcoming lawsuits to right the wrongs and receive compensation for all that you lost, including John O'Keefe, and the toll that this ordeal has had on you and your family. Please give personal and public thanks to Aiden Kearney for all that he has done in bringing attention to the charges that were brought against you by the Commonwealth, where you were acquitted in 2 trials. Aiden deserves your thanks. Please honor him. Thank you. That's nice.
Yeah, interesting. We got a bunch of comments that were along those lines. And, then we had another commenter say, she already thanked Aiden. So I don't want to get into that whole thing. I really don't want to get into that whole thing. I do want to read comment number 4. The guy had dog bites, John O'Keefe, had dog bites all over his arm, exactly where a trained police dog would go for when instructed. The dog was sent away some time after. The house stayed dark until all neutral parties left, and then the lights came on as soon after the coast was clear. And these people are trying to sue her. Interesting.
This is from Pamela Penrose. I like that name, Pamela Penrose.
Penrose, yes, very literary.
Yeah. No amount of money can replace the stress which takes years off your life. Watching your family worry for years must be heart-wrenching. Losing your house and job that you loved. She should get millions and watch everyone involved that set her up suffer worse like she did. Bankrupt them all. an eye for an eye. Take every eye that was involved in this horrific incident. They ruined a time in her life that should have been special. They were all drinking and driving. Why do cops get to drink and drive?
A lot of people had some similar thoughts right after January 29th of 2022 when this whole thing happened. And we, especially after we saw the videos inside McCarthy's and the waterfall of the cops themselves drinking and then driving around. And it's like, you know, good point. Very good point. Number 2. This is from Irene Nerm. I think we've had this person on before and we've never figured out how to pronounce your name. I'm sorry. I apologize. Key points in the complaint underpin the entire case. There are several references to the destruction of cell phones that were, in parentheses, soon to be preserved. In the civil case, I believe Jackson is going to invoke spoliation of evidence and move that all inferences be weighed in favor of the plaintiff. I further believe that any non-corrupt court would grant that motion given the facts as they appear in this case.
It's a good point.
Spoliation of evidence can be either a cause of action or a motion or a defense. And in this case, how it would work is there are several remedies if evidence has been destroyed or secreted or not properly produced in the course of discovery. And in my view, discovery is more prominent in civil cases because we don't have the Brady and Giglio requirements. So we do have automatic discovery, both in the federal and state courts. We do have automatic discovery, but civil attorneys tend to be pretty aggressive about listing interrogatories and requests for production and doing all that kind of stuff. So one of the remedies can be if something is asked for and it's withheld, one of the remedies is that a particular defense can be stricken or certain testimony can be stricken, or as this person suggests, all inferences to be drawn from the lack of production of evidence can be made. So if Brian Higgins, took his SIM card and his phone and destroyed them both and threw them in dumpsters down in a military base in Cape Cod, it is possible that an attorney can move the court to allow the jury to make any inferences like, what did Higgins do? Why did he do that? Why did he lie about going over to the Canton Police Department the night of January 29th, 2022? So, those are remedies that are available to people in Massachusetts. I don't know the law anywhere else. I really don't. But those are remedies that are allowed in the Massachusetts law.
Yeah, in California, spoliation of evidence cannot be a cause of action, but it can be used for, to exclude evidence. And there's a jury instruction that the jury can presume that if the defendant has better evidence that could be provided, but it was destroyed, then the presumption is, in favor of the plaintiff. So, yeah, interesting. Yeah.
And our final comment.
Okay, this is from Christy Reynolds, essay painter, SDAU. I don't know.
She's a regular. From now on, we'll just call her Christy Reynolds. How's that? Okay. She's a regular.
It says, amazing how those same crazy investigators figured out how to log and keep evidence in a chain of custody properly in the BW case, but have no such thing for seemingly weeks or longer in the KR case.
Yeah, that is interesting.
BW is a Brian Walsh, right?
Yes, Brian Walsh case. And it's true, the Brian Walsh case, there have been some other cases that people have pointed out, and I should probably go find one and show what this person is talking about, where Mr. Proctor and all the others that we've talked about here, Tully, they have done a proper crime scene investigation. They've, cordoned it off. They've kept a log of all the people that have come in and out. They've sealed evidence into evidence bags, bagged them and tagged them, kept appropriate logs of chain of custody. So there are cases where they've done that. That is why the Karen Reed case stood out so much, because they didn't do it despite the fact that they know how to do it. So one more thing here. And remember how we got 80 countries? We got a new one this week. We got a new one. Burma, aka Myanmar. It used to be called Burma many years ago, but after some unfortunate events over there, they now call it Myanmar, although a lot of people still want to call it Burma. In any event, we got a new country, so we're now up to 81 countries that have followed our humble little channel. Oh boy, we already did our comments. Let's see, what would we do for what is there any kind of a Hollywood Squares emoji or something like that? I'm trying to think of an emoji for any of you who a what?
TV?
TV, there you go. All right, a TV. All right, thank you for being with us. We appreciate it. I did forget to ask everybody nicely to like, subscribe, and share. And some of the characters in this case are going to ask you to do that and tell you how easy it is right now.
Pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Okay, that's it. Any final words? Any final words, Yoli?
So I guess it wasn't Judge Canoni that was hearing the case.
No, it was not. Her name had been on the docket sheet electronically, but it wasn't to be. Be nice, everyone. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.